Hey everyone, and welcome to This Explainer. Today, we are diving into something that literally shapes the daily lives of millions of people, Massachusetts wage and hour laws. You know, the Commonwealth actually maintains one of the strictest legal frameworks in the entire United States for this stuff. I mean, there is practically zero room for error. So grab a notepad, get comfortable, and let's try to unravel this complex landscape together. All right, here's our roadmap for today. We're going to cover the baseline wage rules, filing a workplace complaint, the strict liability shockwave, navigating the court system, and finally the anti-retaliation shield. Let's get right into it.
Section 1. The baseline wage rules, establishing the playing field.
So if you're an employer, these are your absolute, non-negotiable operational minimums for 2026. And if you're a worker, well, this is your safety net. The general minimum wage sits firmly at $15 an hour. Now, for tipped workers, the service rate is $6.75. But, and this is a big but, employers must calculate the difference on a shift-by-shift basis. That guarantees earnings never fall below that standard $15 minimum. And of course, any hours worked over 40 in a single week demand overtime, which is 1.5 times the regular rate. There's no way around it. These numbers are entirely non-negotiable. Now, this next concept really illustrates how aggressively Massachusetts protects workers right out of the gate. It's known as the ABC test. By default, the state just presumes anyone performing a service for a hiring entity is an employee, period. To legally classify someone as an independent contractor, like a 1099 worker, the employer actually has the burden to prove all three of these rigorous prongs. If an employer fails even one of those three prongs, the worker is legally classified as an employee, and that instantly exposes the employer to liability for unpaid overtime, benefits, and statutory damages. The standard here is incredibly strict.
Moving on to Section 2. Filing a workplace complaint, the mechanism of enforcement.
When we look at the actual data from the Fair Labor Division, something super interesting and maybe a little concerning jumps out. Retaliation for attempted wage enforcement actually leads the pack, making up 14.3% of all complaints. That's a massive piece of the pie. It tells us that the fear of retaliation is a major, everyday barrier to enforcement for real people. Right behind it, at 11%, are disputes over unpaid commissions.
So how does an employee actually fight back? Well, you can't just march straight into a courtroom. The law requires this mandatory exhaustion process first. Under Chapter 149, you've got to file a workplace complaint with the Attorney General's office. It acts as a strict jurisdictional prerequisite. You can do this easily online or by mail. Once it's filed, you enter a 90-day waiting period. After those 90 days are up, or sooner if the state issues what's called a private right of action letter, you finally unlock the door to initiate a private civil lawsuit. Now, while you're waiting out those 90 days, you might be worrying about legal deadlines. To translate some pretty dense legalese for you, toll-in simply means pausing the clock. The standard 3-year deadline to file a claim is legally paused the exact moment your administrative complaint hits the Attorney General's desk. This ensures that administrative review delays at the state level don't accidentally rob you of your window to seek judicial relief. It's a really vital protection built right into the system. All right, Section 3, the strict liability shockwave, the climax of compliance. 3 times. That is a huge multiplier to keep in mind. Under Massachusetts law, if an employee wins a wage claim, the court literally must award mandatory treble, which just means triple, damages, plus attorney's fees. And here is the real kicker. The court has absolutely no discretion to produce this award. Was it an honest mistake? A payroll software glitch? Did you have zero bad intent? Doesn't matter. Ouch. If you violate the Wage Act, you pay triple. Period.
This stark contrast we are looking at highlights the absolute bombshell Reuter decision by the Massachusetts Supreme Judicial Court. For decades, employers relied on the old Dobin standard, which was basically a safe harbor. Under that old rule, if they messed up but managed to pay the late wages before getting sued, they only owed triple the interest on that late payment. Well, the Reuter decision completely killed that safe harbor. Now, paying wages late is an instant, completed violation. It immediately triggers automatic treble damages on the entire principal amount. So even a minor administrative delay instantly triples the underlying financial liability.
Because of that new strict liability, the timing of final paychecks has become an absolute minefield. If an employer involuntarily fires or lays someone off, their entire final compensation, meaning base pay, commissions, and all accrued unused vacation time, must be physically or electronically under the employee's control on the exact day of discharge. Not the next day, the exact day. If a direct deposit clears even 1 day late, that 3 times penalty kicks in. This is exactly why the state's highest court literally advised employers to suspend workers with pay if they need extra time to calculate final wages before officially firing them. On the flip side, if a worker resigns voluntarily, it's slightly more relaxed. The deadline is just the next regularly scheduled payday.
Section 4. Navigating the court system, seeking judicial relief.
So once you finally have your right to sue, you've got to pick the right lane based on the principal amount you're owed. The small claims session is highly popular because it uses really informal procedures and relaxed rules of evidence, but it's capped strictly at $7,000. Now, lawmakers did recently try to raise this small claims ceiling to $20,000 with House Bill 1860, but it failed to pass for 2026, so the limit is stuck at $7,000 for now. Claims up to $50,000 head to district court, and anything exceeding that big number goes straight to superior court for formal civil litigation.
And finally, Section 5. The anti-retaliation shield, protecting the worker.
The statutory shield we are talking about here is incredibly aggressive. An employer is strictly, across the board, prohibited from penalizing or discriminating against a worker who exercises their rights. Obviously, this includes firing them, but it also includes sneaky stuff like cutting their work hours, giving them undesirable shift reassignments, defaming them with false negative references, making false criminal reports, or threatening to report them to immigration authorities. And here is what's absolutely vital to remember. This protection kicks in even if the worker only made an informal verbal complaint to their supervisor about their pay.
Recognizing just how incredibly high the stakes are and the sheer complexity of these laws, the state doesn't just leave workers out to dry. The Attorney General's Fair Labor Division actually partners up with Suffolk Law and volunteer attorneys to run a free monthly wage theft legal clinic. It's such a brilliant resource. Held on designated Mondays, workers can meet with experts to safely calculate owed wages, draft demand letters, and even prepare small claims court complaints, all totally for free.
Well, we have covered a tremendous amount of ground today, from the rigid ABC test to the strict liability of the Reuter decision. I really hope this explainer empowered you to truly understand this complex landscape. So my final question to you is this. Knowing the unforgiving, strict liability of Massachusetts law, is your payroll perfectly compliant? Or, if you're an employee, are you prepared to confidently assert your protected rights? Take a moment to evaluate exactly where you stand. Thanks so much for exploring this legal minefield with me today. Keep asking great questions, and I'll catch you in the next explainer.